Eku Iluna, please rise. Ea ka'aha ho'o kolo kolo ki'e hana hana ua a koa koa ho mai. This Honorable Supreme Court is now reconvened. Inoho ilalu, please be seated.
Please call the case.
Case number SCWC-20-0000727. Roland S. Guieb, individually and derivatively on behalf of Guieb Incorporated, respondent, versus Robert S. Guieb, Guieb Incorporated, Pacific Welding and Manufacturing LLC, Guieb Group LLC, and RSG Enterprises LLC petitioners. Arguing for petitioners Robert S. Guieb, Guieb Incorporated, Pacific Welding and Manufacturing LLC, Guieb Group LLC, and RSG Enterprises LLC, J.D. Ferry. Also appearing is Mike Carroll. Arguing for respondent Roland S. Guieb, Fred Paul Benko. Argument on the merits.
All right, good afternoon. Aloha, everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. And I'd like to welcome and thank our Substitute Justice, Judge Matthew Viola. Counsel, are you both ready to proceed?
Yes, Your Honor.
All right. We've allocated 30 minutes for each side. Mr. Ferry will be giving you a warning with 5 minutes left to go in your initial argument. So you can reserve that time for rebuttal. And Mr. Benko, we will give you a warning with 5 minutes to go during your half hour as well. Please proceed.
Thank you, Your Honor. May it please the Court, John Ferry for petitioners Robert Guieb and the associated entities Guieb Inc., Guieb Group LLC, Pacific Welding and Manufacturing, and RSG Enterprises. I'm here with my co-counsel, Mike Carroll. In the proceedings below, there is a long record going back nearly 8 years to when Roland initiated this action on June 28, 2017, all the way through a 2-week jury trial that concluded late December 2019, followed by the trial court's resolution of additional equitable claims that concluded in the summer of 2020. Then there was an appeal and cross-appeal to the ICA, with each side asserting various errors by the trial court. We're here today to address what we believe are the 3 most striking errors that the IC made in its memorandum opinion of August 7, 2024. And we selected those errors, excuse me, sorry, I'm getting feedback. We selected those errors because they seem most clearly to depart from or flatly disregard this court's precedent and prior statements in 3 different areas, including the law of punitive damages, statutory UDAP or UMOC claims under Chapter 480, and the common law of fiduciary duties. And given the nature of those errors and the questions they raise, it seemed likely that in theory and in practice, those errors will cause problems and confusion, not only in future proceedings in this particular case, but also for courts, attorneys, and parties throughout the state in the future. So we thank the court for allowing us to be here today to discuss and hopefully get some further guidance, clarity, and correction with regard to those 3 errors or areas of law that we highlighted in our application. Essentially, we think that the trial court got it right the first time, granting summary judgment on Roland's kinship fiduciary duty claim and his hybrid UDAP, UMOC claim under HRS 480. And lastly, in response to our motion for judgment as a matter of law, at trial in this case, performing its gatekeeper function with regard to Roland's request for punitive damages and ruling that this case was not an appropriate one to instruct or pass along Roland's request for punitive damages. So now I'll go through those errors, which we believe were erroneous not only in the result reached, but in how the ICA went about reaching them, or appears to have gone about reaching them.
You know, you had mentioned in your initial marks that we should, you know, look at a case to avoid confusion. Now, confusion is the exact basis for their deceptive trade practices, 481A3 Act, as well as the UMOC. And basically they're saying there's confusion with the names, you know, exhaust systems, Hawaii, Kalikai, and that. And plus they are suggesting that the website from your own expert distinguished, you know, did not distinguish between the two companies. I mean, isn't that enough to get count 12 before the jury, and why not?
Your Honor, you're speaking about count 12, which was in the first amended complaint as a sort of mashup, as I read it, of an unfair deceptive acts and practices claim along with an unfair methods of competition claim, with a little bit borrowed from HRS 481A. And we moved for summary judgment on the UMOC claim, which I think is the only claim that actually exists under the law, regardless of how Roland or plaintiffs label that claim under 480. We've pointed out that we don't believe it could have been a UDAP claim, because under 480 2D, only consumers or the state can bring UDAP claims under that.
And I understand that. What about their 481A3, that deceptive trade practices claim? And I understand the UMOC too, because UMOC is carved out of the UDAP.
Well, I think that what plaintiff is trying to do, and what frankly the ICA might have missed, is borrow from 481A3 and that statement that references conduct in violation of this section could be a deceptive trade act or a deceptive act in trade, and using that comment to circumvent or get around the standing requirement, which is pretty clear in 482D and the case law, I think is impermissible and a non-starter.
But aren't they two separate things? I mean, and possibly the remedies are different. I mean, UDAP is not going to allow your punitives, it'll allow trebles, but the 41A3 might be something different. I mean, they are very similar claims. I would agree with you there. But
I'm sorry,
no,
let me finish. In terms of combining the 480 UDAP claim, which does provide for injunctive relief, treble damages, and attorney's fees, with the 481A, I think is where we have a problem with it. I don't think that plaintiffs or anyone, as a non-consumer or not a state agency, can get around the 482D standing requirement by referring to 481A 3. Maybe there's a standalone claim for 481A 3, but I don't think it can be combined and brought back and converted into a UDAP claim under 480 and the remedies it provides without standing under
understood.
480.
But so there is a possible standalone 481A3 claim, right?
There could be, but that's not the way it's pled. That's not the way it's been presented at any point. And I think that that standalone 481A claim would also fail as a matter of law. But we can only react, and we could only move for summary judgment on the claim as it was pled. And I could get into the why we believe that the 481A deceptive act in practice as a standalone claim would also fail. We've briefed it. I think that
How about the UMOC? How wasn't there enough evidence to get that one before the jury?
The UMOC claim under 482E, there would be standing. And as far as the UMOC claim, I think that that is where, for the first element of a UMOC claim, I believe properly that's where the plaintiff could reference the factors listed in 481A3 and say that amounts, or we claim that that amounts to an unfair method of competition, assuming you can prove it. And that might form the first element of a UMOC claim. But we don't see a hybrid UDAP 482 and 481A claim as being viable at all. So I think there's no UDAP claim, and you would have to go to a UMOC claim. And even borrowing from 481A to move that UMOC claim forward, I believe still fails as a matter of law on all three elements. We believe that there couldn't be a violation of HRS 480 or the first prong because we have a generic trade name, Exhaust Systems Hawaii, for a company that describes its own business as providing services dealing with exhaust systems located in Hawaii. And on summary judgment and in our answering brief, we provided a lot of cases that hold generic trade names aren't worthy or don't merit any protection or very little protection under the law of unfair competition and trademark infringement law.
On this issue, this general issue of the 480-2, 481A3, the ICA, in holding that summary judgment was inappropriate, was it based on issues of fact, genuine issues of material fact? I mean, because you're getting into the evidence now, right? Because I thought I heard you say as a matter of law, but now you're talking about the evidence in this case.
Well, on summary judgment, so the ICA held that the trial court erred by granting our motion for summary judgment
Right.
on the UDAP UMOC claim. And we're saying as a matter of law, the trade name is generic, and I suppose that gets into factual issues. I mean, the fact is that the company does have the trade name Exhaust Systems Hawaii, but the law says that a trade name of that generic nature doesn't merit protection as a matter of law.
You're saying there's no dispute that that is the trade name and it's generic.
There's
and
no
that's where your
dispute.
argument flows from. Okay.
And so I suppose the legal dispute on that point would be whether Exhaust Systems Hawaii is a generic name unworthy of protection under unfair competition or trademark infringement law, or whether it is. And there's a certain showing that you need to make in order to demonstrate that the name merits protection, and under the likelihood of confusion test that comes out of 481A. And we made the argument on summary judgment, I think convincingly, and plaintiffs failed to carry their burden in rejoinder that they fail that test. And that would be the first prong of a UMOC claim.
So if someone were to open a business called Exhaust Systems Big Island of Hawaii, you would concede that you would have no claim for confusion against that company?
We might have a claim. I don't think it would be a winning claim.
Isn't that a question of fact?
Well, I don't believe so, Your Honor. I don't think that that would be a claim with any merit, given the state of
You're
the
saying
law with
it's
regard
not
to.
confusing as a matter of law because it's just like exhaust systems include mufflers, right?
Mhm.
So if somebody had a company called Mufflers Hawaii and someone else started Mufflers Hawaii King Street, Mufflers Hawaii Kalihi Kai, it wouldn't be confusing.
You would have to do more to show that that name is worthy of protection.
Okay.
And none of that sort of evidence was brought up in opposition to our motion for summary judgment. But that's where I think that the claim fails as a matter of law on the first prong of a UMOC claim as pled and litigated in this case. And I would also, going back to the ICA opinion, and where I think it's kind of evident that the ICA was off track in its analysis of this claim, they don't mention a UMOC claim or go through the analysis at all. They're speaking of this claim as if it's a UDAP claim. They're referencing a different test. They didn't go through these factors, which we've briefed extensively. Even beyond the first prong of a UMOC claim, the second prong calls for an injury to plaintiff's business or property that flows from the defendant's conduct that negatively affects competition or harms fair competition. That's the nature of competition prong. There was no showing whatsoever in this case that competition itself was injured or harmed. No showing of anti-competitive conduct, as that phrase is recognized under the law. And so the claim would fail on that second element as well.
Well, on the ICA decision, the memo op, they referenced some expert testimony on this issue, right? Is that the issue that it goes to?
That was defendant's expert
expert.
testimony, Your Honor. And respectfully, the statement in the report was taken out of context.
Okay, so it's how you view the evidence.
It has nothing to do with the analysis of whether they've alleged or proved an anti-competitive conduct or injury to the nature of competition, or how our conduct, alleged conduct, amounted to a cognizable injury under that prong.
What about the website? What's your answer to the ICA's comment about the website suggesting that it appears the two separate entities are actually one entity, although they're not?
Yeah, I think that, again, it's that stray comment is taken out of context from our expert's report. That expert report ultimately concluded that the trade name had no discernible value whatsoever. Plaintiffs have come up with no competent evidence to show that the trade name goes beyond a generic trade name that doesn't merit protection or has any value whatsoever. I think if you read on in the portion of that stray comment from our expert report that plaintiff is mistakenly, and the ICA mistakenly relying upon, it continues that in practice, if there are services that the Kailua or Waipahu shops are unable to provide, the work is referred to the GGLLC Kalihi Kai shop. That's because these different shops provide different scopes of services. And there wasn't any anti-competitive conduct, as that phrase is understood in the law.
Direct your attention to the punitive damages claim.
Thank you.
Mr. Banco, in his reply to your CERT app or response, talks at length about factual events in this case that provided, in his view, clear and convincing evidence of fraud that would support the giving of an instruction on punitive damages. What's your response to that?
Well, we respectfully disagree. We think that what happened in this case is that the court first ruled before trial began that plaintiffs needed to make out a prima facie case, clear and convincing evidence of the sort of conduct that would justify the extraordinary remedy of punitive damages. And unless plaintiff could make that showing in the court's eyes, it wasn't going to be allowed to reference, instruct, or request that extraordinary remedy from the jury. And the trial court performed its function as instructed by the court in Ketting and looked at the standards set up in Masaki and decided that for all the accusations and allegations that have been made by plaintiffs, in the end, this is a business dispute. Punitive damages are not compensatory in nature. Even in the case of a finding of fraud will not necessarily result in an award of punitive damages. And the trial court properly decided that this simply punitive damages was not an appropriate remedy. In this case, looking at all the evidence, and that if plaintiff was going to be awarded any form of compensation, it was going to be compensatory damages for the claims instead of the extraordinary, what's supposed to be an extraordinary remedy under the law. And the effect of Mr. Bankel's arguments and plaintiff's claims and the ICA's treatment of them in this case, and I think perhaps going forward, is going to be threefold perhaps. Number one, the trial court is no longer going to have the gatekeeper role that the court emphasized was obvious in Ketting. Tort claims that are labeled as fraud or mere allegations of wrongdoing that are sufficient to make it past summary judgment or a Rule 50 motion are going to automatically come with punitive damages requests passed through to the jury automatically. And we don't think that that's what the court...
Isn't the trial court just going to evaluate the case and whether or not there's sufficient evidence for it to go to the jury? I mean, on any given case, I don't see why somehow it's going to open the floodgates to every single case meriting a punitive damages instruction.
It could. Your Honor, I think that in this case, the trial court performed its function properly as gatekeeper. And while I'm not screaming that the floodgates to punitive damages are going to open up, I think that preserving that role and how the trial court performed it in this case was correct. And I think it's important that the trial court have that role preserved and be allowed to perform it.
I think, one argument that you made was essentially what the ICA was doing was it was bootstrapping, the findings of compensatory damages and fraud and that and whatnot to justify a punitive damages award. And I think your position probably is fraud's not enough. You need something more. What more do you need?
I think you need what Masaki tells us, which is something more. You need evidence, clear and convincing evidence of a mindset and conduct that is almost criminal in nature and deserves to be punished. And given the dangers that punitive damages present for defendants, especially financial and reputational ruin, these sort of safeguards are important to keep in place. So I think it is a different analysis, and the distinction between tort liability and compensatory damages on one hand and the extraordinary remedy of punitive damages on the other does need to be preserved in the trial court, who sat through a trial, sat through a jury trial, is in a much better position to make that call than the ICA.
You know, it's kind of interesting, or well, maybe it is only to me, but you're talking about it being a matter of law, whether punitive damages are going into the jury. But then you're also, on the other hand, suggesting that there's some kind of an abuse of discretion as the trial court, who is the person who is on the ground hearing all the evidence. I mean, what sort of deference should we give to that trial court in their analysis of a matter of law?
I think that there does need to be deference to the trial court's discretion in that regard, especially whereas here there were rulings on motions in limine that have never been challenged on appeal, where the trial court said plaintiffs are going to have to make a prima facie case of punitive damages before I pass or allow you to pass instructions and a request to the jury for this extraordinary remedy. Trial court sat there and, in the interest of justice and what it had seen, and said this is not an appropriate remedy for this case. If there's going to be compensation, it'll be in the form of compensatory damages that, in the eyes of the jury, will make the plaintiff whole.
Can I ask, pardon me for interrupting? There was a fraudulent non-disclosure claim that went to the jury.
Correct.
And the jury returned a verdict in favor of the plaintiff on that claim. Is that correct?
Correct.
Did that claim require the jury to make a finding that your client's conduct was either intentional or at least willful, or there was some element of conscious wrongdoing?
Technically, for a non-disclosure claim, intent is a requirement, and so that would be correct. However, punitive damages, as we read Masaki and the trial court's function under Ketting, is to look at the evidence and say there might be intent as far as this tort goes, but for punitive damages, there's got to be something more.
But isn't this something more already incorporated in all the standards that Masaki lays out? Is it something more than a typical tort, a negligence kind of tort? Something more is the conduct is, at least under Masaki, can include intentional wrongdoing. There's some element of conscious wrongdoing, and it seems to me that that fraudulent non-disclosure claim, there was at least sufficient evidence to go to the jury on. And then the jury actually found that there was fraudulent non-disclosure, which incorporated some intentional misconduct. So just under at least Masaki, why wouldn't the punitive claims, the claim for punitive damages, which is derivative, why couldn't that have gone to the jury?
Well, number one, I would like to point out that plaintiff's own attorney, eventually the jury awarded damages on a verdict form for Roland's individual claim for fraudulent non-disclosure, and I think that was a mistake by the jury in multiple respects. One being plaintiff's own counsel said Roland doesn't have an individual claim for fraudulent non-disclosure. The jury awarded it anyway. Secondarily, though, I would disagree, Your Honor, that Masaki stands for the proposition that if there's an intentional tort claim and liability, that automatically means punitive damages are on the table. Masaki relied on the case of Kang versus Harrington, which says explicitly, even the finding of fraud will not necessarily result in an award of punitive damages. And in light of that statement, as well as all of the statements in Misaki where there's got to be maybe intent required to do the tort, but yeah, something more, something almost criminal in nature in terms of the mindset, the conduct, willful, malicious intent to cause that specific harm. And that's on the side of the ledger that I think that the plaintiff or the claimant has to come up with, and the jury, trial court needs to decide, is it there or not? And another part of the same calculus that the trial court needs to make is these punitive damages are an extraordinary remedy. They have there's a severe risk of financial and reputational ruin that needs to be guarded against. And so I don't think that the two can travel together automatically.
Mr. Ferry, we're getting up close to your 30 minutes. I will give you some time, extra time for rebuttal, but I wanted you to address the fiduciary claim based on the sibling relationship.
Okay, thank you.
If you could briefly.
Okay. Excuse me. This was another claim where the trial court granted summary judgment in advance of trial, and this was another instance where we believe that the trial court got it right and the ICA erred. This is essentially, by recognizing this claim, the ICA essentially gave rise to or recognized a new common law cause of action for breach of fiduciary duty based purely on kinship alone. In the past, unreported or reported cases in Hawaii have always had additional factors present. I think we pointed this out in our reply, whether it's infirmity, old age, incompetence, something that informs or gives rise to that special duty, in addition to kinship. There's no such factors here at all, and that wasn't even disputed on summary judgment. Furthermore, the primary relationship that's at the center of the dispute here is the business relationship. And there's evidence, and I think it's not disputed, that for years that relationship had not been, there was some distrust already in that relationship. And I saw in opposition to our application on this issue, there being, and in the ICA opinion, there being reference to Roland stating that in 1991 or so, he, based purely on kinship, he agreed to the 55-45 split in terms of ownership and structure of Guieb Incorporated. This lawsuit was filed in 2017. How long are we going to hold that one supposed instance of reliance against Robert solely based on brotherhood? Moreover, that split was suggested by lawyers. Everybody agreed to it. And at the end of the day, Robert, for the longest time, split profits and income 50-50 down the middle regardless. So to me, that accusation is just, there's no real detrimental reliance going back 35 years that should give rise to any sort of new claim based purely on kinship or imposition of a new special duty.
Anything further? If you could wrap up, we're
sorry,
running a bit.
Sorry.
No, you can feel free to make your last point, and then we'll I'll give you a bit of time on rebuttal.
The last point that I would make on that is, furthermore, there were other avenues to pursue fiduciary duty claims available to Roland in this lawsuit, which goes back to the fact that this is primarily a business dispute. And Roland brought individual and derivative claims for breach of fiduciary duty against Robert. They went to the jury. The jury found no liability against Robert for breach of fiduciary duty at trial. That's all I have.
Thank you for your argument. Mr. Benko.
Your Honors, good day. My client, Roland Guieb, is here in court today, and I propose to make my arguments in the following order. First, I'd like to lay out a position which sort of levels the field. I think some statements in the petition filed by Robert's side sort of misleading. Secondly, I will address each of the three issues with this court and, of course, entertain the questions. By the way, my name is Fred Benko.
I'm sorry, I couldn't hear the last thing you said.
By the way, my name is Fred Benko.
Okay.
Turn it.
You got to stay about 6 inches away from the mic, is that right? Yeah, thank you. You do your best.
Defendants, in their petition for writ, repeatedly make the argument that Roland is in this solely for a windfall. In fact, they say Roland has a long-running quest for financial windfall. How does that square with the real facts of the case? Roland worked for the company prior to lawsuit, still works for the company, 31 years. For those 31 years, he dutifully, humbly, and diligently managed one or the other of their shops. 6 days a week, not 4.5, not 5.5, but 6 days a week. And for 15 of those years, as he's doing now, he drives from Eva Beach to Kailua. So we believe that this long-running quest for windfall is erroneous. In fact, what Roland did by filing this suit was try to avoid financial devastation.
As far as filing that suit, Brother Robert says, and I'm focusing on the UDAP claim and the 481A3 claim. We've heard arguments this afternoon that those basically collapse. They're not essentially independent claims. Your UDAP falls because you're not the consumer, you're not the AG, you're out. They're also saying you're out on the 481A3. What's your response to his comments to us on that?
Your Honor, when the legislature tried to establish our antitrust laws, it's my impression with all the amendments that they were trying to fill in every puka, so you could not avoid the impact of our antitrust laws, of which 480 and 481 and 482B are part of. As a result, when they tried to fill in the pukas over the many years, they established that they established that any person can file an unfair competition claim. Now, you might be limited to injunctive relief at the end, but they established that, quote, any person can file an unfair competition claim. I think that's what we have here. It's got to be sort of made a hybrid with the unfair and deceptive practices. But again, it's part of the legislature's overall concern that Every time we set up a law, somebody will find a way to break it. Unfair competition does not require any special standing, such as the state or a consumer. The law clearly states any person. More so on the unfair practices claim is the fact that Roland did not prove any loss of business, loss of any product sales, and therefore cannot prove damages under the unfair competition laws. However, I'd point out that the unfair competition law specifically states that in order to prevail in an action under this chapter, a complainant need not prove competition between the parties or actual confusion or misunderstanding. I believe in our case, through the trial's transcripts, you will find evidence where vendors, customers, the mail people confused Roland's long-running company with Guieb Group, Robert's new company. So I think we adequately covered that based on the legislation that was in the books. This court was interested in punitive damages. What I would like to point out is a bit of a factual history of this case, because in defendant's brief, they never mentioned what the wrongs were. Unbelievable. 11 pages, 13 footnotes, and you wouldn't know what happened. What happened was, in order to start this coup against Roland, Robert first dismissed him from all capacities as a treasurer. Can't deposit the monies, you can't sign checks, you can't do this, you can't do that, you can't even call yourself a treasurer anymore. He did this in order to wall off Roland from what was to come. Roland would not get any timely information based on Robert's initial stab, which was cut him out from all financial information. What happened after that? Within a couple of days, Robert, without telling anybody, not even the 35-year financial consultants, Robert, the fancy word is misappropriated, I would call it loot. He looted the King Street shop for himself. Keep in mind that he also kept the lifts in the King Street shop. He also kept the inventory in the King Street shops. And he did one more thing. He hired away the manager of the King Street shop, most profitable shop, and hired him for his new Guieb business. That wasn't all. Of course, we all know he walked into DCCA, canceled the Guieb Inc. from the trade name, and the same day put in Guieb Group as the owner of the trade name. I don't call that misappropriation, I call it looting the company. Again, it's unbelievable, but Roland didn't know about these activities. Going to work 6 days a week, pumping away to make the company stronger.
You know, on this punitive damages claim, I think the argument from opposing counsel is that the trial court needs to be able to be a gatekeeper. And so I think the question for us might be like, what is the standard? What are the considerations for being that gatekeeper? Do you disagree that the trial court should be the gatekeeper for allowing a punitive damages claim to go to the jury? That's what I mean.
I would say a wise gatekeeper. And I've had many punitive damages cases which this court has looked at. When you become a gatekeeper on an important issue like fraud, where there is, and I was interested in this, so many cases refer to quasi-criminal. What is a quasi-criminal act? Finally found in the case law, a quasi-criminal conduct involves some kind of moral turpitude, and how appropriate in this case, where Robert misappropriated a whole shop, misappropriated all the equipment in the shop, expensive equipment, misappropriated all the inventory, and then hired the very good manager away from Guieb Inc. and hired him for Guieb Group. It's sort of unbelievable. So
Well, I mean, that might be bad or ethically challenged or whatever you want to label it, but how is that not just, business? I mean, how does that transform into malice, spite, all those, oppressive, wanton, malicious that sort of go hand in hand with our case law on punitive damages?
Right. Well, first of all, no corporate formalities. He just did it. Number two, no disclosure to anybody. You remember from the record, Larry Anderson said, well, I didn't know what had happened for several months until I saw the shop over there on King Street have lower income. Roland did not know about it for several months until he realized that something was wrong. So that's an indication of fraud.
Well, so that proves or purports to prove and probably does prove your fraud element, but isn't there something more you need, something egregious? And the trial court here said that, in looking at things, looking at the motion in limine, hearing the evidence, that I just don't have that extra oomph to give punitive damages. And
he had just listened to the testimony or saw affidavits about the happenings that occurred. So in fact, there was a pretty good record in front of the judge. Let me answer that with one more sentence. Robert's side cited Kang versus Harrington. I think every attorney in town eventually runs across Kang versus Harrington. One sentence in Kang versus Harrington responds to your question, Justice. Clearly, and you remember Kang versus Harrington, they had a rental agreement. Harrington changed it in his favor to give himself almost a everlasting, eternal leasehold interest in that property. But the Supreme Court of Hawaii did write clearly in the instant case, Appellant Harrington did not act in good faith, intending to benefit either Mr. Kang or society in general. Rather, as in Anderson and Howell, two cases involving fraud and punitive damages, Appellant Harrington acted intentionally and for his own benefit. That, to me, responds to the question, did he act for himself? Yes, he did. And did he act intentionally? Well, he didn't change all the paperwork for the King Street shop by magic. He did not take over the trade name by magic. He did those acts intentionally. And I'm afraid we have a case that clearly should have gone to a jury, no matter what the trial judge thought. He should have at least given it to the jury to see if they heard what he heard. And I would point that out as my response to, should we have gatekeepers
In giving that claim to the jury, let's ask about another claim to the jury, the UMOC claim, the 482 and E. You know, that's all part of Chapter 480. 480, the UDAP does not allow punitive damages. Do you, if we side with you that UMAC is, or if we say UMAC is in the game, let's say, there's no punitives, right?
That's an interesting question. I had it come up in another case years ago. My client won both punitive damages on fraud, and he won unfair and deceptive trade practices. At the end of the trial, he had to make a decision on which one to accept. That's an election that's made many times across the country. Punitive damages or unfair and deceptive with triple damages.
Well, I mean, are you suggesting we allow plaintiffs to kind of shoot from the hip? Hey, I got this claim or this claim, and then kind of heads you win, tails I also win kind of thing? I just, that seems I don't know how that would work in practice. And then you saying that then later the court would come in after the jury verdict and ask you, do you want trebles or punitives? And you pick whatever you got more of? That doesn't seem like much of a gatekeeper role, by the way.
Pardon?
That doesn't seem like much of a gatekeeper role.
It's an appropriate use of the gate. Present them to the jury. Let the jury decide if they both come out. Remember, the unfair competition is characterized by the fact that you don't necessarily get damages, but you get injunctive relief, triple damages, and your attorney's fees. So all that has got to go into the calculation. Which one does your client accept? You don't get both of them.
Mr. Benko, may I
Yes.
ask a question on the punitive damages issue? So is it your position that if there is sufficient evidence to present a claim to a jury, and the claim involves as an element some intentional misconduct, that there should always be, the jury should always consider whether to award punitive damages?
I would respond this way, Judge. It's sort of a trivial way to answer you. When they steal an ongoing muffler shop and its trade name, yes, that should qualify for punitive damages. But if they take from Long's drugstore a greeting card, that's probably not going to get you punitive damages of any kind. I think there's qualities in what's being swiped, what's being looted, that should come to the fore.
Well, let me ask you along the lines of just Judge Viola's asked a couple times with regard to intent. You know, I look at the civil jury instruction that would go to the jury, and it actually has grossly negligent conduct. Shouldn't there be differences between, let's say, personal harm tort, like the products liability case in Masaki, versus business competition fraud claims?
Distinctions.
Yeah. Why? I mean, if this went to the jury and they gave the civil jury instruction, then the jury is looking at punitives if it is grossly negligent, the conduct. That doesn't seem right.
I would agree with this court. I cannot see the wording in Masaki right now. I don't know if grossly negligent is in there, but I would agree that probably the gatekeeper should not give punitive damages award or send that to the jury if there's gross negligence, although I am sure there are hundreds of cases around the country which award punitive damages for gross negligence. If you're an airline pilot and you're drinking on the job while flying your plane, that might qualify.
Well, it might be reckless disregard of it might be that, but I hear you.
As to your quality of the conduct, too, the other factor consideration in Masaki is you need clear and convincing evidence. So for a fraud claim, you're working with preponderance of the evidence, right? And punitive, you're dealing with a higher standard of proof.
Right. In punitive damages, and this goes to the protection, say, of the trial judge, you have clear and convincing evidence burden. We sort of established that in a Kekona case years ago. And secondly, you have the requirement for a unanimous jury.
Mm-hmm.
So we had a unanimous jury in this case.
I guess in terms of the gatekeeper function for the judge, though, I think because that's the question that's before us in terms of shouldn't the trial judge be the gatekeeper, and if so, what's sort of the considerations for that? And in terms of some of the questions you've gotten, I guess what comes to my mind is that clear and convincing evidence aspect needs to be part of that gatekeeping function.
Yes, and in our case, clear and convincing evidence was proven on whatever fraud claim we succeeded on in that case. I agree. This gatekeeper is protected, in my opinion, by the fact that they have to prove it by clear and convincing evidence. And generally, you have to have a unanimous jury. We had a unanimous jury. So it was error in our minds, which was corrected by the ICA.
Can I ask you? Oh, I'm so sorry.
No,
CJ.
I was going to jump to the fiduciary duty claim. The claim for fiduciary duties are based on the sibling relationship. What's your position with regard to that? The opposing side says it's a completely new cause of action that is being crafted and by the ICA. What's your response?
My response is simply this. I've had this issue before. That Swift case mentioned by the ICA was one of my cases. We got it reversed and sent back for retrial. But it's not a new cause of action in Hawaii. I was shocked when I read that. The first case was in the year 1910, where the Supreme Court ruled that you can have fiduciary duties created by close kinship. Of course, other things being involved in trust, reliance. That was 1910. 1926, in the Meheula case, the Supreme Court ruled in the same manner that you can have fiduciary duties created by close kinship with other factors around. I think
Isn't that what Mr. Ferry's point is, that there aren't other factors here?
Not anything that would dissipate the cause of action.
No, I think his point is you need something like infirmity, some kind of dependent relationship, age, or something plus. You need something more than just siblings. That, I believe, is his point. And his argument is that something more wasn't present here.
In our answering brief to the ICA, we pointed out 2 Illinois cases where the parties that were involved in this argument, 2 sets of parties, 2 cases, they were young adults. There was no other factor involved. One party entrusted another party, or trusted another party to their detriment, and they won relief in the court by the same theory of fiduciary duties created by kinship.
Now, but those people and the individuals in SWIFT with the elderly parents, I mean, that's a little different than when kins are in business with each other, and you raise a separate fiduciary duty claim. So why isn't that redundant with your count 4 kinship claim?
For this reason, I have yet to find a case, certainly in Hawaii, but anywhere else, which says, oh, if you lose on this fiduciary duty, a business fiduciary duty, you're precluded from raising this other fiduciary duty. Haven't found the case yet.
But didn't I mean, or couldn't the court do what the Chief Justice suggested? Hey, there's got to be a little bit more here. You know, I mean, is your point that they were lifelong brothers, so therefore that automatically gives a fiduciary duty?
Well, one thing here is my client retired from his work as a bartender down in Waikiki long time. He gave up everything in order to join
Well, they
his
might
brother.
say he made the wise call. Up until the litigation, I suppose.
You might be right on that. When they split the company 45-55 in 1991, that was long before any pilikia arose between the brothers. It was done in good faith, not to create pilikia, in reliance in the record of the brothers' claim that, oh, nothing will be different, we're going to do everything the same. Well, it didn't turn out that way. You see, my light is on, and I will
You have additional, that's just your 5-minute warning, so.
Okay.
You get
If I don't get any more questions, though I invite them, Plaintiff Rowland prays that this court will affirm the August 7th, 2024 opinion directing the trial court on remand to instruct the jury on punitive damages, unfair competition, and fiduciary duties based upon close kinship. Plaintiffs also request any other relief, equitable or legal. Thank you very much.
All right, thank you, Mr. Benko, for your argument. Mr. Ferry, your rebuttal. We've gone over a bit, but if you could keep it to the point, that would be great. Thank you.
Thank you, Your Honor. I don't have much to add, but just to rebut a few points. Mr. Benko started out his argument by asserting that compensation was not a motivating factor for this lawsuit. I'd point out that we have discovery responses in the record that show that Roland was claiming early in the litigation $5 million in punitive damages and seeking a total damages award or claiming an entitlement to a damages award of $9.2 million. So compensation or a desire for compensation is obviously a factor in this case. And I would add that because punitive damages are not supposed to be compensatory in nature, but rather solely for the purpose of punishment and deterrence, the trial court's performing its role properly doesn't really, in the eyes of the law, cause Roland to lose anything compensable. I guess he's lost an opportunity to try and have Robert punished or financially ruined. But I think from the beginning that this punitive damages has been looked at more as a compensatory element for plaintiffs than properly. I also heard Mr. Benko concede that trial courts should play a gatekeeping role in a jury trial and that they should do so using the clear and convincing evidentiary standards. So I have no argument with regard to that. I do want to circle back to the UDAP and UMOC distinction. 481A3 does provide for its own set of remedies. None of them that are specified in that statute say explicitly link back to 480-2 as other statutes in that same neighborhood do. I think 482B4, which was cited in Davis Four Seasons, does have an explicit reference to 482, unfair, deceptive acts and practices and methods of competition. There's none in 481A3. And so I really don't think there's anything in the law, and as we've previously outlined, there's any support for the proposition that you can use 481A3 by itself to bootstrap you back into a UDAP claim under 482 and open up the availability of statutory treble damages, attorney's fees, awards, and injunctive relief under 480.13. There's no support for it. The court has been pretty clear that the requirements for putting forward a statutory UDAP claim under 482D are limited to consumers and the state, and so the plaintiffs would be limited to a UMOC claim, arguably under that statute, and the claim also fails because, as we pointed out in our motion for summary judgment and in our reply, which are docket number 74 and 174 in the record, as well as our answering brief in the appeal, there was no competent evidence of any damages. That would be the third element. And on the second element, no allegations, no proof as to the second element, the nature of competition. And I don't have anything else to add, so I suppose that's it.
Very well. Thank you to both our attorneys for your arguments today. The court will take this matter under advisement.
Thank you all very much.
Iku Una, please rise. Ua ho'o ku'u ia mai ne ke a aha ho'o kolo kolo ki ke hano hano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.